मैं भारत का संविधान हूँ।
जानिए अपने संविधान को।
Welcome to another episode of All India Radio's newly launched program, Know Your Constitution. Yesterday we had discussed the fundamental rights under the Constitution. Today we are discussing fundamental rights of the Constitution. We have with us Dr. Surat Singh, a constitutional expert and Supreme Court lawyer. Welcome, Dr. Surat Singh. Tell us what is the concept of fundamental rights?
See, Satya Prakash, we fought our Indian freedom struggle on the ground that there were certain fundamental values, fundamental rights which are available to any person born in a country. And since we were not having those, so the entire emphasis was that we should have those. One is, of course, right to equality, that every person will be treated equally in the eyes of law. Another one is freedom of speech and expression, freedom of movement, freedom of practicing any profession, then freedom of religion. Untouchability, of course, was also a big issue. So all these fundamental values which make our life meaningful. Gandhiji used to say that the meaning of democracy is that we should have the effective say in those decisions that shape our life. So if our life is shaped by decisions and we do not have any say in those, then that is not a free democratic society. So fundamental rights are those basic values by which we as an individual pursue the pursuit of excellence both at individual level as well as for society and the state. And that's why definition of state under Article 12 is given that fundamental rights are available against state or state instrumentality.
So what you are suggesting is fundamental rights are essentially rights against the state, and the state cannot touch certain rights which are guaranteed to individuals.
Absolutely. And for that purpose, freedom from constraints, different kind of constraints, they are couched in negative sense, in the sense that government cannot do that, state cannot do that. So they are more in the nature of restriction on the government, and government both at central level as well as state level. And that's why Article 12 of the Constitution defines state, which includes government both at central level as well as state level and local level also, and any other authority. And the way Supreme Court has interpreted the term local authority is that any organization which is cast with any public duty or receiving public funds would be considered other authority.
Well, there are political scientists who say that a state is not supposed to touch our fundamental rights. Why? Because in the first place, the state came into existence because of the fact that people were living in a state of nature in terms of social contract theory. And because they were living in a state of nature, they were living in constant fear of losing their life and property. And hence, what they did was they surrendered certain rights in favor of the state. Not that the state existed that time. Whatever entity which exercised power at the local level, so society or members of the society, they surrender certain rights in favor of the state. And in lieu of, it was done in lieu of the protection offered by the state. And the rights which we never surrendered to the state, they became fundamental rights, and they are termed as inalienable rights.
You are absolutely right about that. In fact, John Locke, in his famous book, Second Treatise on Government, basically argued what precisely you have said, that people are lord unto themselves in the state of nature.
Yes.
And since they have no restriction, but there are some problems, as you have pointed out, so they agree to surrender some part of their sovereignty so that in the totality they are beneficiary. And those fundamental rights are right to life, liberty. American Constitution also, in Declaration of Independence, Thomas Jefferson wrote that these rights are fundamental: right to life, liberty, and pursuit of happiness. Pursuit of happiness is like right to property, which was also a fundamental right in our Constitution. But later, because of so many problems it created for interpretation, it was taken away, replaced by property as a legal right only.
Under Article 300 capital A.
That's correct.
Yeah, but I'll come to some of the most important rights. We have already discussed the concept of a state. Why a state? The definition of state is part of Part 3 of the Constitution, that is fundamental rights. But to start with, the one of the most important rights is a right to equality. Right to equality under Article 14 of the Constitution, which uh, which actually says the state, it talks about equality before law. The state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. And it means there are two parts of Article 14. One is equality before the law and equal protection of the laws. And it is available to non citizens as well.
Absolutely, because the word person is used. Like, for example, in Article 19, when freedom of speech and expression are there, the term citizen is used, but in Article 14, the term any person is used. Person means even non citizens are entitled to right to equality as well as equal protection of laws. Uh, so now the way Supreme Court has interpreted, and it's very important in Maneka Gandhi's case, that every person has the right to fair treatment. So they have extended it to the extent that any government or government agency, while doing any duty, must ensure that there is a fairness of treatment to all the persons. And we as a lawyer take advantage of this, whether it's admission to universities or employment or tender, anything. So we utilize that Article 14, 19, 21 to go to the court to ensure that the government machinery acts in a reasonable, just and fair manner.
Well, Article 14, it's important, but Article 15 and 16, both, in fact, 14, 15, and 16, they're all together considered to be equality clause.
Absolutely. And 15 says that there cannot be any discrimination on the ground of race, religion, gender, place of origin. And 16 is about same right which you have rightly pointed out. Article 14 applicable in terms of employment opportunities.
Equality of opportunity in matters of public
Absolutely.
Employment. But 15, it has been amended, and now 15, there are several clauses which have been added to 15. There are some clauses which have been added to 16, and some of the provisions, so far as 15 and 16 are concerned, there have been matters of dispute.
The entire issue of reservation, particularly under Mandal Commission report, was subject matter under Article 16, and 9 judges of the Supreme Court, as you know, decided that matter, that yes, this Article 16, because of reservation, has been matter of interpretation before the Supreme Court. And Article 15, Satya Prakash, is also important because it says no discrimination on the ground of gender, on the ground of religion, race. So cases like where women are not allowed entry to temple, all these are covered under Article 15. Similarly, on the ground of religion, you can't discriminate. So though these things are also, freedom of religion is also there in Article 25 to 30, but in this case, specific law has been made that you will not discriminate anybody on the ground of gender or place of religion, place of the origin or religion. And not only that, special laws can be made under 15 for children.
And 15,
that's exactly right. For children and for women. So if you want to make laws which are favoring the women because of past discrimination, those are allowed.
But there is a concept of reasonable classification under Article 14. Can you explain it to our listeners? Because there is too much controversy regarding classification.
Well, for last, from 1950 till 1977, the classification, whenever we said about right to equality, it was said that like should be treated alike, means persons who are similarly situated should get the same treatment. So classification can be made, but classification itself should be reasonable. But later, in 78, in Maneka Gandhi's case, Supreme Court came out with a much more superior concept that it is a right against discrimination, that it is a right against arbitrariness, and that was far more comprehensive than reasonable classification. So now the latest law on the subject is that every act of the government or its agency must be reasonable, just and fair. And if it is not, then that classification will be struck down.
Well, under Article 16, you have already mentioned how a reservation for other backward classes was granted, was done during 1990, and then it was upheld by the Supreme Court in 1992 in Indira Sahni's case. But tell us, thereafter, there were several amendments in the Constitution. 77th Amendment, 82nd Amendment, 1st, 2nd, and 5th Amendment regarding a certain reservation in promotion and carry forward rule and some related issues. One of the most contentious issues has been the reservation in promotion, and the Supreme Court has in several cases declared it unconstitutional, and there is a constitution, some of the issues are still pending with the Supreme Court thereafter in the second round, and there is an attempt on the part of the political parties that to amend the constitution again to allow it. Just tell us, does it violate the equality clause?
It's a very serious
Because
issue,
the-
and in a brief discussion, it cannot be resolved. There are views on both sides. There are views on the sides that if initial appointment has been given and a person has been integrated, then making promotion reservation in promotion will perpetuate that unnecessarily, because once a person has been given the chance, he should be treated as integrated. But on the other hand, there are other schools which say that since all those people against whom they compete, they have the advantage of several generations. So even at promotion stage, promotion should be allowed. Initially, reservation at the stage of promotion was denied by Supreme Court, but then Parliament made a law that even at the stage of promotion is allowed. Again, controversy occurred. So since vested rights are there, so that's why these kind of a controversy will keep on. In fact, whether there should be reservation or not itself is a big issue in which over and again there are serious debates in Parliament.
Well, this is important because Article 335 of the Constitution, which says the claims of members of the scheduled castes and scheduled tribes shall be taken into consideration consistently with the maintenance of efficiency in administration in making appointments to the service and posts in connection with the affairs of the state. So it talks about striking a right kind of balance between social justice and efficiency in the administration.
Well, the famous case of Balaji, in fact, earlier in 60s,
Yes.
which was also followed in Mandal Commission case, said that on the one hand, as you have rightly pointed out, there are claims of social justice, but at the same time, we have to see that efficiency of administration due to lack of merit does not suffer. So the rule of thumb was 50-50, that 50% for efficiency, 50% for social justice. But then again, there has been controversy that can this 50% exceed, particularly after SC, ST, other backward classes also started demanding reservation. And now, unfortunate thing is that reservation now is not a sign of weakness, but it's a sign of political strength. Whosoever is politically strong, they keep on demanding reservation for themselves, even if they don't need it. So, this reservation, which was basically as a tool of giving chance to those who have been discriminated for a long time, has become a political tool now.
Yes, and now that 10% reservation has been given to economically weaker sections of the society, the issue is pending before a constitution bench.
Yes.
Listeners, you are listening to yet another episode of All India Radio's newly launched program, Know Your Constitution, and today we are discussing fundamental rights. Welcome back, Dr. Singh. Now let's move on to some other provision. Untouchability has been abolished, and now we have several laws starting with the 50s and then 70s and late 80s. In 1989, the SC/ST Prevention of Atrocities Act was amended, was brought in to ensure that scheduled caste and scheduled tribe members, they are not discriminated against, or rather they are not you know unfairly targeted in the society. Recently, the Supreme Court diluted some of the provisions, and thereafter there have been protests, and then almost all the provisions they have been restored. Tell us something about the purpose for which this law was brought in.
There are two concerns here. On the one hand, we have to make sure that nobody is discriminated on the ground of caste, particularly the past disadvantages, particularly in case of scheduled caste and scheduled tribe. But at the same time, this is India, and false allegation or misuse of the law cannot be ruled out. So in some cases, a law which has been made with a very, very benevolent purpose may be abused for ulterior reasons. So for example, in case of scheduled caste, scheduled tribe, it was a good provision that anybody who discriminates or call anybody by caste name should be punished. So much so that it was made non-bailable offense. But then there was no provision of giving right to that person. How do we make sure that it's not a false complaint? So some safeguards were needed. So Supreme Court thought that without giving opportunity and without examining the veracity of the claim, a person should not be denied of his life and liberty on the other hand. So he was trying to strike a balance between social justice on the one hand and right to a fair investigation to the other. But then, given Indian conditions, there is another fact that when you go to the police and file a complaint, sometimes police does not register the complaint or does not take any action.
Yes.
So keeping that in view, again, Parliament insisted and review was filed, and then Supreme Court have restored the previous position. Now these are the issues which are much more, see, apart from the law, Satya Prakash ji, in every country what we call there is a constitutional morality.
Yes.
For example, I studied in England. In England there is not written constitution till date.
Yes.
But there was always certain customs and traditions. For example, Prime Minister will never make a major policy decision without consulting opposition leader, for example. It is not written anywhere. But there was an understanding. And no Prime Minister has ever disobeyed since last 300 years. In India, on the other hand, the democratic ethos, democratic morality, social justice morality is not deep down, particularly in the recent year. Maybe in Vedic period it was different. So as a result of that, when instead of statesmen, politicians come into power, they create all kind of issues which constitution try to prevent.
One of the most important rights guaranteed to every citizen is right to freedom. And there are several kinds of freedoms. Right to freedom of speech and expression, right to assemble peacefully and without arms, right to form associations or unions, right to move freely throughout the territory of India, right to reside and settle in any part of India, and right to practice in any profession or to carry on any occupation, trade or business. Dr. Surat Singh, the most important right among the right to freedoms is right to free speech under Article 19(1)(a). And we all know Article 19(1)(a) is subject to reasonable restrictions under Article 19(2), and there are 8 reasonable restrictions mentioned under Article 19(2), including the sovereignty and integrity of India, security of state, friendly relations with foreign states, public order, decency, morality, or in relations to contempt of court, defamation, or incitement to an offense.
Right.
This concept of reasonable restrictions, in a way, it's a sort of a balance between rights and obligations, or rights and duties. Why? Because American Constitution doesn't have any restriction whatsoever.
Well, in American Constitution, you are absolutely right. When Constitution was drafted over there, no restriction was placed. But through judicial interpretation,
Yes.
over the years, American Constitution was in 1789, so more than 200 years. Over the years, Supreme Court came out with that no right is absolute right if you have the right of freedom of speech and expression, then other person has also right to make sure that you do not defame him. So as in England they say that your right stops where my nose starts. So you have the right to move around with your stick, but if your stick is hitting the nose of other person, then your right stops.
Yes.
So in a sense that apart from the rights, there are mutual obligations also in public morality, in sovereignty and integrity of nation. For example, if somebody says, "Desh ko tukde tukde kar do," now that cannot be treated as a part of speech and expression, because you cannot have the freedom to speak against the sovereignty and integrity of India. You can discuss about quality of government, you can discuss about policies, you can say our foreign policy should be this way or that way, but within the bounds of the Constitution.
Yes.
So if you are speaking against the sovereignty and integrity, you can't say it's your freedom of speech and expression.
That ends there, and the law will take its own
Absolutely.
course. There are several. One of the articles under the Constitution, rather provisions under Article 19, was Article 19(1)(f), which was done away with during emergency, after emergency, during 1978.
Right to property.
Right to property in 1978 through 44th Amendment. Till the time it was there on the statute book, rather Constitution, what kind of problems the Indian polity and the administration faced, because there is a long history
Yes.
disputes, judicial or rather legal disputes in courts, and that ultimately led to basic structure theory.
Some of the most important cases of constitutional law in last 38 years, 28 years in fact of Indian democracy were concerned with the right to property. For example, Golaknath is one of the most remarkable case. It was right to property. And the most important case in the history of Indian Constitution so far is Kesavananda Bharati's case, 1973,
Yes.
where the entire full bench, that is of 13 judges of the Supreme Court, interpreted. And that was again right to property. So since the entire controversy was right to property, and it is only who were rich could go to court more often than poor, this was raising the controversy so much that finally it's in 1978, when Janata Party came into power, it was decided that let's take it out from the fundamental right and add it as a legal right, as you rightly pointed out, 300A. So since what is the meaning of property, how much compensation should be given, whether compensation should be reasonable, just or fair, whether it should be just any amount. So entire controversy was centered on that. In fact, largest number of cases were on that ground only.
But one of the amendments, the very first amendment to the Constitution, which created ninth schedule of the Constitution, that was also aimed at dealing with this problem, because many of the laws enacted by state legislature, or laws primarily to deal with, abolition of Jamidari and land reforms laws, they were all being challenged. So ultimately Parliament had to create ninth schedule and put all those laws in the ninth schedule to save them from judicial scrutiny.
But interestingly enough, now since the Land Acquisition Act, for example, was grossly abused by state governments,
Yes.
so Supreme Court, through interpretation from 2011 onwards, have come to the point that right to property cannot be taken away totally, otherwise other rights will become meaningless. And they have said, for example, that the government cannot abuse this power of taking acquisition, what we call eminent domain, so as to do injustice. So in other words, that right to property through interpretation is coming in a different way. Another way is that when we say government action should be reasonable, just and fair in every area of life, that includes property also.
And also in 2007, the Supreme Court in the Iyer Coelho case said even laws placed in the ninth schedule, they are not completely immune to
Absolutely.
Judicial scrutiny.
Yes.
Now coming to Article 21, one of the rather the most cherished right under the Constitution. In the last 7 decades, the Supreme Court has expanded the scope and ambit of Article 21 like anything. Now the latest being, they have added right to privacy also to it. And Article 20 capital A, right to education, has been made a fundamental right, which was there in the Directive Principles of State Policy under Article 45. So the entire the issue of expansion of fundamental rights, how in the last 7 decades fundamental rights have expanded like anything, and there is a section of a section in the academia and intelligentsia which says this expansion of fundamental rights on the part of the Supreme Court should be done with sense of circumspection.
Well, we have to keep in mind that in 1950, the very first case which came before the Supreme Court, that is Gopalan case, A.K. Gopalan case versus State of Madras, the interpretation given by the Supreme Court was very, very narrow. And in fact, it continued, where in fact, a person who was preventively detained, A.K. Gopalan, did not get any protection from the Supreme Court. And gradually it was realized that that kind of narrow interpretation is against the letter and spirit of the Constitution. And then from bank nationalization case and other cases, gradually, particularly with the help of that famous lawyer Nani Palkiwala, Supreme Court came to realize that when we say that no person shall be deprived of his life or personal liberty except according to procedure established by law, just one sentence. But the issue was, what is the meaning of that procedure? Whether the procedure it should be reasonable, just and fair. Ironically, and you would not believe that in 1950 Supreme Court said any procedure will do. But in Menaka Gandhi's case in 1978, they said no, not every procedure itself should be reasonable, just and fair.
That is due procedure.
And then freedom of religion is also given in Article 25 to 30th, which is very important.
Article 25, right to religion, is one of the weakest rights under the Constitution, because it starts with it is subject to all other provisions. But there is a unique provision under the Constitution, Article 26, which grants fundamental right to religious denominations, which is a very unique kind of provision. Perhaps there is no parallel elsewhere.
Well, as far as India is concerned, it has been always full of tolerance for other religion. If you see the European history, they've been fighting among themselves like anything, even in other countries also. India, Sarvadharma Sambhav, is the only country from the very beginning, at the beginning of Vedas also, Sarve Bhavantu Sukhine, Sarve Santu Niramaya, means everybody should be happy and there should not be any discrimination. That kind of spirit was there in India from the very beginning, which is our strength. And that strength, in fact, we should keep. But at the same time, when you are saying right to religion cannot be absolute, because public morality, public order are to be also kept in mind.
And rest of the fundamental rights. Well, Article 30 grants right to establish and administer educational institutions. This right is available to religious and linguistic minorities. And of late, there are demands from certain groups belonging to majority community which say that this right should be available to them also.
Well, this right, in fact, in the beginning was used much more as a sword rather than as a shield, that you are a minority and lot of protections are given to them. But at the same time, it was felt that in the name of minority, it is not that the majority should be repressed. So Supreme Court gave now interpretation that yes, this right is there, but at the same time, even in case of unaided minority schools and all that, you have to follow certain uniform standard. For example, even students of weaker section are to be admitted. So a balance has been struck between
and ceiling of 50%.
And ceiling of 50%. And in a famous case, capitation fees, Union Krishnan, there also Supreme Court said that capital quota can be there, management quota can be there, but at the same time, merit is also to be kept in mind.
Well, with this, we come to the end of this program, and we'll be back with another program on Know Your Constitution. Thank you very much.
Thank you.
मैं भारत का संविधान हूँ।
जानिए अपने संविधान को।